Appendix A. Legislative History of Child Support Enforcement. 1950. Congress passed the first federal child support enforcement legislation by adding Section 402(11) to the Social Security Act, 42 U.S.C. 602(11), requiring state welfare agencies to notify appropriate law enforcement officials upon providing aid to families with dependent children, AFDC, with respect to a child who was abandoned or deserted by a parent. Also that year, the National Conference of Commissioners on Uniform State Laws and the American Bar Association approved the Uniform Reciprocal Enforcement of Support Act. Subsequent amendments to this act were approved in 1952, 1958, and 1968. 1965. Public Law, PL. 8997 allowed a state or local welfare agency to obtain from the Secretary of Health, Education, and Welfare, the address and place of employment of an absent parent who owed child support under a court order for support. 1967, PL 9248 allowed states to obtain from IRS the addresses of absent parents who owed child support under a court order for support. In addition, each state was required to establish a single organizational unit to establish paternity and collect child support for deserted children receiving AFDC. States were also required to work cooperatively with each other under child support reciprocity agreements and with courts and law enforcement officials. 1975. After 3 years of congressional attention to child support enforcement issues, PL 93-647 was signed into law on January 4, 1975, creating, inter alia, Part 500 of Title IV of the Social Security Act, Sections 451, 8 Sec., 42 U.S.C. 651 et Sec. The child support enforcement provisions of PL 93-647 are, in brief, as follows. The Secretary of Health, Education, and Welfare, now the Department of Health and Human Services, DHHS, has primary responsibility for the child support enforcement program and is required to establish a separate organizational unit to operate the program. Operational responsibilities include, 1. Establishing a parent locator service, 2. Establishing standards for state program organization, staffing, and operation to assure an effective program, 3. Reviewing and approving state plans for the program, 4. Evaluating state program operations by conducting audits of each state's program, 5. Certifying cases for referral to the federal courts to enforce support obligations, 6. Certifying cases for referral to the IRS for support collections, 7. Providing technical assistance to states and assisting them with reporting procedures, 8. Maintaining records of program operations, expenditures, and collections, and 9. Submitting an annual report to the Congress. Primary responsibility for operating the child support enforcement program is placed on the states pursuant to the state plan. The major requirements of a state plan are that, 1. The state designate a single and separate organizational unit to administer the program. 2. The state undertake to establish paternity and secure support for individuals receiving AFDC and others who apply directly for child support enforcement services. 3. Child support payments be made to the state for distribution. 4. The state enter into cooperative agreements with appropriate courts and law enforcement officials. 5. The state establish a state parent locator service that utilizes both state and local parent location resources and federal parent locator service. 6. The state cooperate with any other state in locating an absent parent, establishing paternity, and securing support. And, 7. The state maintain a full record of collections and disbursements made under the plan. Procedures for the distribution of child support collections received on behalf of families receiving AFDC were set out. Incentive payments to states for collections made on AFDC cases were created. Monies due and payable to federal employees became subjected to garnishment for the collection of child support. New eligibility requirements were added to the AFDC program, which required each applicant for, or recipient of, AFDC to make an assignment of support rights to the state, to cooperate with the state in establishing paternity and securing support, and to furnish his or her social security number to the state. The effective date of PL 93 to 647 was to be July 1, 1975, except for the provision regarding garnishment of federal employees, which became effective on January 4, 1975. Several problems were identified prior to the effective date, though, and Congress passed PL 9446 to extend the effective date to August 1, 1975. In addition, PL 9488 was passed in August 1975, to allow states to obtain waivers from certain program requirements under certain conditions until June 30, 1976, and to receive federal reimbursement at a reduced rate. This law also eased the requirement for AFDC recipients to cooperate with state child support enforcement agencies when such cooperation would not be in the best interests of the child. It also provided for supplemental payments to AFDC recipients whose grants would be reduced due to the implementation of the Child Support Enforcement Program. 1976. Effective October 20, 1976. State employment agencies were required to provide absent parents' addresses to state child support enforcement agencies, PL 94-566, 1977. P.L. 9530, effective May 23, 1977, made several amendments to Title 4D, provisions relating to the garnishment of a federal employee's wages for child support were amended to 1. Include employees of the District of Columbia. 2. Specify the conditions and procedures to be followed to serve garnishments on federal agencies. 3. Authorize the issuance of garnishment regulations by the three branches of the federal government and by the District of Columbia. And 4. Define further certain terms used. Section 454 of the Social Security Act, 42 U.S.C. 654. was amended to require the state plan to provide for bonding of employees who receive, handle, or disperse cash, and to ensure the accounting and collection functions be performed by different individuals. The incentive payment provision, under Section 458A of the Social Security Act, 42 U.S.C. 658A, was amended to change the rate to 15% of AFDC collections, from 25% for the first 12 months and 10% thereafter. The Medicare-Medicaid Anti-Fraud and Abuse Amendments of 1977, PL 95-142, effective on October 25, 1977, established a medical support enforcement program, under which states could require Medicaid applicants to assign to the state their rights to medical support. State Medicaid agencies were allowed to enter into cooperative agreements with any appropriate agency of any state, including the 4D agency, for assistance with the enforcement and collection of medical support obligations. Incentives were also available to localities making child support collections for states and to states securing collections on behalf of other states. 1978. The Bankruptcy Reform Act of 1978, PL 95-598, which was signed into law on November 6, 1978, repealed Section 456B of the Social Security Act, 42 U.S.C. 656B, which had barred the discharge in bankruptcy of assigned child support debts. The Federal Bankruptcy Act was subsequently repealed as of October 1, 1979, and replaced by a new Uniform Law on Bankruptcy. Section 456H of the Social Security Act was reenacted by Section 2334 of PL 9735, 1980. Section 2 of PL 96-178 extended until March 31, 1980, Federal Financial Participation, FFP, for non-AFDC services, retroactive to October 1, 1978. The Social Security Disability Amendments of 1980, P. L. 96-265, were signed into law on June 9, 1980, increasing federal matching funds to 90%, effective July 1, 1981, for the costs of developing, implementing, and enhancing approved automated child support management information systems. Federal matching funds were also made available for child support enforcement duties performed by certain court personnel. In another provision, the law authorized the use of the IRS to collect child support arrearages on behalf of non-AFDC families. Finally, the law provided state and local 4D agencies access to wage information held by the Social Security Administration and state employment security agencies for use in establishing and enforcing child support obligations. The Adoption Assistance and Child Welfare Act of 1980, P.L. 96-272, contained 4 amendments to Title 4D of the Social Security Act. The law made FFP for non-AFDC services available on a permanent basis. It allowed states to receive incentive payments on all AFDC collections as well as interstate collections. Third, as of October 1, 1979, states were required to claim reimbursement for expenditures within 2 years, with some exceptions. The fourth change postponed until October 1980. The imposition of the 5% penalty on AFDC reimbursement for states not having effective child support enforcement programs. 1981. The Omnibus Reconciliation Act of 1981, PL 9735, added 5 amendments to the 4D provisions. First, IRS was authorized to withhold all or a part of certain individuals' federal income tax refunds for collection of delinquent child support obligations. Second, 4D agencies were required to collect spousal support for AFDC families. Third, for non-AFDC cases, 4D agencies were required to collect fees from absent parents who were delinquent in their child support payments. Fourth, child support obligations assigned to the state no longer were dischargeable in bankruptcy proceedings. Finally, the law imposed on states a requirement to withhold a portion of unemployment benefits from absent parents delinquent in their support payments. 1982. The Tax Equity and Fiscal Responsibility Act of 1982, PL 97-248, was signed into law on September 3, 1982, and included the following provisions, which affected the 4D program. FFP was reduced from 75 to 70%, effective October 1, 1982. Incentives were reduced from 15 to 12%, effective October 1, 1983. The provision for reimbursement of costs of certain court personnel costs that exceed the amount of funds spent by a state on similar court expenses during calendar year 1978 was repealed. The mandatory non-AFDC collection fee imposed by PL 9735 was repealed, retroactive to August 13, 1981. P.L. 97-248 allowed states to elect not to recover costs, or to recover costs from collections or from fees imposed on absent parents. Another provision clarified states' authority to collect spousal support in certain non-AFDC cases. As of October 1, 1982, members of the uniformed services on active duty were required to make allotments from their pay when support arrearages reached the equivalent of a 2-month delinquency. Also beginning October 1, 1982, states were allowed to reimburse themselves for AFDC grants paid to families for the first month in which the collection of child support is sufficient to make a family ineligible for AFDC. The Omnibus Budget Reconciliation Act of 1982, PL 97-253, effective September 8, 1982, provided for the disclosure of information obtained under authority of the Food Stamp Act of 1977 to various programs, including state child support enforcement agencies. Title X of the Uniformed Services Former Spouses Protection Act, PL 97-252, signed into law on September 8, 1982, treats military retirement or retainer pay as property to be divided by state courts in connection with divorce, dissolution, annulment, or legal separation proceedings. 1984. The key provisions of PL 98-378, the Child Support Enforcement Amendments of 1984, require critical improvements to state and local child support enforcement programs in 4 major areas. Mandatory practices. All states must enact statutes providing for the use of improved enforcement mechanisms, including 1. Mandatory income withholding procedures, 2. Expedited processes for establishing and enforcing support orders, 3. State income tax refund interceptions, 4. Liens against real and personal property, security or bonds to assure compliance with support obligations, 5. Reports of support delinquency information to consumer reporting agencies. In addition, state law must allow for the bringing of paternity actions any time prior to a child's 18th birthday, and all support orders issued or modified after October 1, 1985, must include a provision for wage withholding. Federal financial participation and audit provisions. The Act encourages greater reliance on performance-based incentives by reducing federal matching funds by 2% in federal fiscal year 1988, to 68%, and another 2% in fiscal year 1990, to 66%. Federal matching funds at 90% are available for the development and installation of automated systems to improve required procedures, and, for the first time, computer hardware purchases can be matched at this higher rate. The Graham-Rudman-Hollings legislation may impact these percentages. Starting October 1, 1985, states will receive an incentive minimum of 6% for both AFDC and non-AFDC collections. These percentages can increase to as much as 10% for both categories for very cost-effective states. But a state's non-AFDC incentive payments are limited by the amount of incentives available for AFDC collections. The law further requires states to pass incentives through to local child support enforcement agencies where these agencies have participated in the costs of the program. The Act modifies the requirement of auditing each state annually to one of auditing each state at least once every 3 years. The Act also alters the focus of the audits to the extent that, beginning with the FY86 audit period, states' effectiveness will be evaluated on the basis of program performance as well as operational compliance. Graduated penalties of from 1 to 5% of total payments to the state under the AFDC program may be imposed if a state is found not to have complied substantially with federal requirements over successive periods. However, the penalty may be suspended if the state opts to take corrective action, over a maximum period of 1 year, to come into substantial compliance. Improved interstate enforcement. The proven enforcement techniques discussed above must be applied to interstate cases as well as intrastate cases. Both states involved in an interstate case will be allowed to take credit for the collection when reporting total collections for the purpose of calculating incentives. In addition, the law authorizes OAKS to commission special demonstration grants beginning in fiscal year 1985, to be made available to states to fund innovative methods of interstate enforcement and collection. Federal audits will also focus on states' effectiveness in establishing and enforcing obligations across state lines. Equal services for welfare and non-welfare families. The Act amends Section 451 of the Social Security Act to provide that Congress, by creating the Child Support Enforcement Program, intended to aid both non-welfare and welfare families. In addition, the Act contains several specific requirements directed at improving state services to non-welfare families. All of the mandatory practices discussed above must be made available for both classes of cases. The interception of federal income tax refunds is extended to non-welfare cases. Incentive payments for non-welfare cases will be available for the first time. When families are terminated from the welfare rolls, they automatically must receive non-welfare support enforcement services without being charged an application fee, and states must publicize the availability of non-welfare support enforcement services. Other provisions. In addition to those provisions identified above, the Act requires that states, 1. Collect support in certain foster care cases. 2. Collect spousal support in addition to child support where both are due in a case. 3. Notify AFDC recipients, at least yearly, of the collections made in their individual cases. 4. Establish state commissions to examine, investigate, and study the operation of the state's child support system and report findings to the state's governor. 5. formulate guidelines for determining appropriate child support obligation amounts and distribute the guidelines to judges and other individuals who possess authority to establish obligation amounts. 6. Offset the costs of the program by charging various fees to non-welfare families and to delinquent absent parents. 7. Allow families whose AFDC eligibility is terminated as a result of the payment of child support to remain eligible to receive Medicaid for 4 months. And 8. Seek to establish medical support orders in addition to monetary awards. In addition, the Act also makes the Federal Parent Locator Service more accessible and effective in locating absent parents. Sunset provisions are included in the extension of Medicaid eligibility and federal tax offsets for non-AFDC families.